They don't go away in bankruptcy. Trust fund liability. Never take the payroll money and give it to anyone other than the IRS. That's a federal crime. Hazardous waste liability. If you buy a property that has hazardous waste under the property that you didn't know about, and the government finds out and it costs $1 million to clean it up, who's responsible? The person who put it there, who is nowhere to be found and bankrupt, or you, the innocent owner? Even though you paid $3,500 for a Phase 1 environmental report, and somebody came out, they look at aerial photos since the Wright brothers started flying in Pinellas County. They look at this, they look at that, there's no dead grass anywhere, you're fine, the bank loans you the money, you now own the real estate. It turns out that your neighbor digs a hole and finds that there's some gasoline under there, et cetera, and your insurance doesn't cover this. So never put commercial property or investment property in your name. Because even if you sell that property and the next person owns it when it gets found, you are in the chain of title. And when you are in the chain of title, your ladder has fallen. So you always want to be judgment proof, and you always want to insulate for that type of liability. Child support and alimony also never bankruptable. Don't even think about getting married if you're not married. That's the best personal advice I can give you, right? If you have your family limited partnership, which is owned 95% by you and 5% by your daughter, then it can own investments like a Nevada LLC that loans money to people. Why wouldn't I have the partnership loan money to people? Because if the lender accidentally breaks the Dodd-Frank law, which is really thick and easy to do, then they sue for punitive damages against the partnership, and you lose all your assets. So I would have the partnership own an LLC and have the LLC make the loans. And some clients have 3 LLCs, and they have 6 loans, 2 in each LLC, because of the Dodd-Frank law. So then another LLC owns a hedge fund investment. Why wouldn't I have the partnership own a hedge fund investment? Here's why. When Bernie Madoff went under, a client of mine got sued by the bankruptcy court for $9 million because he got more out of the Bernie Madoff funds than other investors on average. That's called the clawback. So if you're in a private hedge fund, you can't tell what's going on. I'll mention that also under Business Law 101. Are you investing with people who are not having to be accountable? And do you really think you're going to get your money back? But that's why whenever a client does a private deal, I want that in a separate LLC because of the clawback. Or you enter into a business arrangement with somebody else, and there's an operating agreement, and you sign it without letting me look at it. That happens all the time, and I make 60 times as much money later. Because it turns out that that operating agreement says that you have a capital call obligation, and you get sued, another alligator. So that would be under a separate LLC. Debt against assets. So a lot of you have companies which have assets and ongoing businesses, and you have no liability. But you could just have your company owe you money. So if my legal practice has $300,000 worth of equipment, but it owes me, or it owes, better off, it owes Marcia $270,000, and you get a judgment against my practice, what's going to happen? Marcia's going to force a sale at the courthouse stairs of all of our assets. She's going to be able to bid $270,000. The creditor's not going to be willing to pay anything for them. So basically, the creditor comes up short. So all you need is a promissory note and what we call a security agreement, a UCC1 filing. But you have to talk to your accountant about whether you can borrow that or not. Now, something a little bit more complicated at page 31 that we sometimes do is you could get a lender to actually loan you that $270,000, and then you could put that $270,000 into a creditor-protected vehicle like an annuity or a life policy or even maybe a creditor protection trust. And at pages 32 through 35, I just show you some more. Get people you deal with to give you waivers, releases, and hold harmless. I waive any right to sue you. I release you from any liability if I get hurt on your property. I agree to hold you harmless if anybody that I'm dealing with sues you because of my activities. So we can't all put these in our customer agreements, not for some professionals, but most businesses, you can put this in the agreement. And I had a situation last week where there's a big fight over whether the water in a rainstorm came in through the window, which was the landlord's responsibility, or came in through the floor, which was the tenant's responsibility, because the tenant stupidly filled up the ditches so that the side would look better. So the water, where'd the water go? Right onto the wood floors of these people's business. They're blaming it on the windows. So, but fortunately, the lease says that the landlord will not be responsible even for negligence and even for not maintaining the duties that the landlord was supposed to take. So that's where this client has a lot of, a lot of protection. He wouldn't have had that if the lease had not been well written.